who are said to have some significant tie to al-Qaeda, some significant tie to something like the Cole bombing or 9/11 or you name it, right? It's not going to be difficult, whatever the Supreme Court does with the specific intent requirement or anything else here to prosecute those folks under the material support statute. There's a separate question in military commissions, which is, is material support a traditional law of war offense? Remember, the MCA was passed in 2006. Everyone who's, going to be prosecuted under it pretty much has been put into detention way before that, so there's a retroactivity question, which the government can only get around if it argues that all the offenses you can charge under the MCA, the Military Commissions Act, are in fact traditional, offenses against the common law of war, that they were already offenses. The MCA just puts it down into the U.S. Code. Now, that's a question the government is going to lose, and it doesn't really matter what the Supreme Court does here. It's going to lose that because, again, these are conspiracy and material support are just, unknown in concept in, kind of half the world. They have never been traditional law of war offenses. 4 justices on the Supreme Court laid this out in great detail in Hamdan. Justice Kennedy decided you didn't have to go that far. But that, again, is, while just about every charge sheet in the military commissions has material support sort of on it, with, I think, 2 exceptions, the flaws with using that as a charge in military commission are not going to be affected, and they are probably fatal, although they'll probably only emerge 4 years down the road when those cases hit the federal courts.
Well, I was going to say, just as a point of information, I think the question of whether material support as defined by the Military Commissions Act is a viable and valid charge was actually argued to the so-called Court of Military Commission Review, I think 3 weeks ago. In the Hamdan and al-Balul cases. So, I agree entirely that I think it's very unlikely that anything the Supreme Court says in this case will bear on those cases. But that's sort of yet another issue about the general idea of material support that is percolating in the courts today.
Hello, my name is James Sanford. I'm a student at the Howard University School of Law, as well as a member of Charity and Security Network. I had a question as to, as far as the legal arguments that have been presented, has it been brought up the conflict or the seeming conflict between the material support statute and the principles of international law pertaining to charitable organizations, specifically principles that have been brought forward by the Red Crescent and the International Red Cross as far as neutrality and humanity goes, and how that may affect international organizations, charitable organizations, to really do their work within the international community?
I'm sorry, I don't know a whole lot about it. I feel like, you folks may actually have some stuff written up on that.
I'm not an expert on this, but yes, I mean, the nonprofit world operates on principles of moral, basically promoting basic human rights and human, the principles of international charity, here they are, which are in the last page of how the work of charities can counter terror, because actually terrorism is the opposite of what we are seeking. And so I'm not sure exactly, your question is the relevance of international law to this case, and I'm not sure about that legal question.
And I think legally, the reality is that it is a sort of colorable but not particularly likely to convince argument for the current Supreme Court that they should interpret the material support statute in light of governing international law. This court is really not that wedded to the notion that international law has much to say about, especially domestic criminal statutes, and has been less willing to use the so-called charming Betsy canon, pursuant to which we're supposed to interpret statutes in a way that's not inconsistent with international law when criminal statutes are at stake, usually because other canons, the rule of lenity, the constitutional avoidance canon, et cetera, will do similar work. I think here the problem is that because Congress has been legislating so specifically in response to this exact litigation, there's less of an argument that the law is unclear, or at the very least that Congress's intent is unclear. It's just a question of whether Congress can override these international law norms the way that it has attempted to.
Mm-hmm. Yeah. I'm not sure we spent any of our 30,000 words, at least at the Supreme Court, raising the international law issue. So I could be wrong.
Okay, I'd just like to ask each of our panelists to, or give them the opportunity if they would like to make any closing remarks, particularly on the likely impact of this case or the narrowness and likely not impact of this case once it's actually decided.
We'll see. Yeah, that's all I got.
You know, this case is about speech, as it's, you know, in terms of the issues that are at issue right now at the Supreme Court. Obviously, there are broader things that our plaintiffs wanted to do over the years, particularly in Sri Lanka. But it's worth reemphasizing again, the Supreme Court has never upheld such a blanket criminalization of political speech that seeks to further only lawful, nonviolent activity.
And I'd summarize by saying this case is about the ability of U.S. NGOs and civil society to participate in the stated U.S. interests in democracy, governance, human rights, and that it's counterproductive to those interests.
Thank you. Okay, did you want
I'd like to close this out for today by thanking you all for coming and thanking our speakers. The oral argument in this case is set for next Tuesday, February 23rd at 10 a.m. in the Supreme Court. That afternoon at 3:30 p.m., the Center for Constitutional Rights, Supreme Court Institute, and Georgetown Center on National Security Law will be holding a symposium on the oral argument that will include speakers from both sides of the case. We encourage you to continue to follow this issue. It's obviously we have a problem. The Supreme Court decision may or may not help solve it, but in the end, between the courts, the Congress, and us as the public, we need to reconcile our national security needs with our human rights and free speech principles, and that's where we think this should be heading. So again, thank you for coming, and please join me in thanking our panelists and moderators.